Okay, hi guys. Today I will talk about a very important legal tool that protects business information in the United States. This tool is called a Non-Disclosure Agreement or NDA. NDAs are widely used um, in business to make sure that sensitive information does not leave the company or organization without permission. In this lecture, I will explain what NDAs are, why they are used, their key elements, and how they are applied in practice. I will also include examples from real cases to make the discussion more understandable. My goal is to give you a clear picture of how NDAs work in the real business world and in US law. A non-disclosure agreement is a type of civil contract. It is an agreement between two or more parties that sets rules for how confidential information should be handled. The main purpose of NDA is to protect information that has value for a business, is not known to public, and is protected by reasonable security measures. In the United States, the Defense Trade Secret Act, or DTSA, provides rules for protecting trade secrets, which are a type of confidential information. An NDA can be signed as a separate contract or included as part of another contract, such as an employment contract, partnership agreement, or investment agreement, for example. In any case, the purpose remains the same: to prevent unauthorized disclosure or use of confidential information. Now let's look in detail at the main parts of this agreement. Each of these parts is very important because they determine how well the agreement protects information and how it will be enforced in court. The first thing an NDA must do is clearly identify the parties. This is very important because it determines who has the rights and responsibilities under the agreement. The NDA should include the full legal names of all parties, including jurisdiction for companies, clear rules, the disclosing party, which is the party sharing information, and the receiving party, which is the party receiving it. Representatives such as agents, consultants, and contractors who will also have access to confidential information and must follow the same rules also should be added. Affiliates and subsidiaries, if they will also receive the confidential information, also should be added. Common mistake is to mention only the main company and forget about contractors or other third parties. If these parties are not included, they might not be legally bound to keep information confidential. The definition of confidential information. It is a heart of the NDA. It must be broad enough to protect all important information, but specific enough to avoid confusion. The well-written NDA usually combines two approaches: specific categories such as technical documents, business plans, clients' data, financial information, algorithm, research, development, product specification, and at the same time a general description such as any information with economic value that is not publicly known. It is important to remember that confidential information must be protected in any form. This means written, oral, electronic information must all be treated as confidential. The receiving party has several responsibilities. Usually, they must not share the confidential information with any third party, use the information only for the purpose described in the NDA, protect the information with reasonable security measures, such as using passwords, limiting access, and not making copies unless allowed. And ensure that any representatives, such as employees or consultants, also follow the same confidentiality rules. A common mistake is not clarifying whether the receiving party can share information internally, for example, with different departments or external advisor. The NDA should always clearly define who can see the information. And NDA also needs to explain when its rules do not apply. Common exceptions include information that is already publicly known, information that has that the receiving party knew before signing the NDA, information received legally from a third party, information independently developed by the receiving party, information that must be disclosed by law or court order, usually with prior notice to the disclosing party. In general, the receiving party must prove that one of these exceptions applies. This prevents misuse of the exceptions. Federal law. In the United States, there are federal laws that affect NDAs and trade secrets. Defend Trade Secrets Act. The DTSA allows companies to file civil lawsuit in federal court if the trade secrets are stolen or misused. Remedies can include injunctions to stop misuse or information, compensatory and punitive damages, payment of attorney fees. The law also protects whistleblowers, allowing employees to report legal violation to the government or lawyers without being held liable. For example, in the case Tata Consultancy Services versus DXC Technology in 2022, a federal court used the DTSA to prevent the use of IT infrastructure data that had been taken in violation of an NDA. Uniform Trade Secret Act, most states, 47 of them, have adopted the UTSA, which provides rules for defining and protecting trade secrets. Some states like New York and Massachusetts have their own variations. Courts in the states often treat NDA breaches as misappropriation of trade secrets. For example, in Silicon Image Incorporation versus Analogics Semiconductor case, a California court treated a breach of an NDA as a trade secret theft under UTSA. Go to the state regulation. Different states in the US law, different states in the US have different rules, have different law about NDAs. California, here NDAs are valid only to protect specific trade secret, not general skills. There is strong protection for whistleblowers. Example, in Edwards versus Arthur Anderson LLP case, The California Supreme Court invalidated even narrow non-compete agreements. We will talk about non-compete later, but I want to mention that some NDAs are writing closely to NCA non-compete clauses, and even such clauses can be invalidated in California, even they have scope, territory, duration. Doesn't matter. Any NDAs, NCAs that protect more like general skills, they will be invalidated. The next, Texas and Delaware, it's a business-friendly jurisdictions. Texas recognizes a broad definition of confidential information and the inevitable disclosure doctrine, which can prevent a former employee from using trade secrets in a new job. Delaware also strongly protects NDAs, especially in corporate sphere. New York has some specific law. NDAs cannot be used to hide harassment or discrimination unless the victim agrees. And there are strict rules about consent and review periods for such cases. So it can be used to hide harassment, but in New York, there are some specific rules, procedures, review period, and other things. And sometimes NDAs include extra clauses such as non-compete, NCA, non-solicitation clauses, NSA, and non-circumvention clauses, NCC. Non-compete agreements, NCA, stop the receiving party from working with competitors. These are valid if reasonable, but not in all jurisdictions. As I mentioned before, California is such jurisdictions. California, Minnesota, and some other jurisdictions, they do not allow use NCA agreements with some employees, maybe with business partners, but also it is some restrictions. Non-solicitation agreements stop the receiving party from taking clients, partners, or employees, usually enforceable if specific. Non-circumvention clauses prevent the receiving party from bypassing the disclosing party to deal directly with its clients. Courts usually accept these clauses. Here are some important examples. Let's take closer a look at 3 important court cases that help us to understand how NDAs and related agreements work in practice. Each case shows different aspects of protecting confidential information and trade secrets. The first one, Kavani Oil versus Birken Corporation. In this case, the Supreme Court confirmed that trade secrets can be protected alongside patents. Background was Kavani Oil and Birken Corporation were both companies working with chemical products. They both had valuable technical information. The question was whether the trade secrets could receive legal protection even if a patent was also available. The court ruled that NDAs and trade secrets protections are valid even when the same information could be patented. Patents give public disclosure in exchange for exclusive rights, but trade secrets allow a company to keep valuable information private. So this case shows that NDAs are important because they allow companies to protect sensitive information that might not be patented or might be kept secret for competitive reasons. In other words, NDAs and trade secrets are additional tools alongside intellectual property law to safeguard business assets. The next case, IBM versus Papermaster. This case is an example of the inevitable disclosure doctrine in action. Mark Papermaster was a high-level executive at IBM. He accepted a new job at Apple, a competitor. IBM argued that even if Papermaster did not plan to share confidential information, his new position at Apple would inevitably lead him to use IBM's trade secrets because his work was so closely related with new position. The court issued an injunction, which is a legal order that stopped Papermaster from starting work at Apple for a certain period. The court did not need proof that he had already disclosed secrets. It was enough that disclosure was likely due to the nature of his new position. This case demonstrates how NDAs and trade secrets laws can be reinforced by court when a former employee moves to a competitor. Companies must identify who has access to critical information and may use NDAs or other agreements to prevent competitive harm. The last case, Amazon versus Powers. This case deals with non-solicitation agreement, which are clauses often included in NDAs or employment contracts. Powers was an employee at Amazon. After leaving, he tried to hire Amazon employees for a different company. Amazon argued that this violated the NSA, which prevents a former employee from poaching staff for a certain period. The court upheld the NSA, confirming that Powers would not recruit Amazon employees for 12 months after leaving. This prevented Amazon from losing valuable staff and protecting their business relationships. NSA are effective legal tool to protect the company's workforce and clients' relationships. When drafting NDAs or employment agreements, companies should include clear NSAs to prevent former employees from harming the business. I want to mention that wording is very important. In a lot of cases, even small changes can affect whether the NDA is enforceable. Clear language protects confidential information better. Restrictions should match the business need. NDAs and related clauses should be proportional and overly broad rules may be invalid. Show real protective measures, label documents, limit access, secure digital files, and train employees. Court check if company actually protects the information. If not, so what is the problem? Proof of harm is needed for damages, but injunctions can still apply. Courts can stop misuse of information even if exact losses are not proven. And now let's look at some frequently asked questions about NDAs. I will also give you some tips on what to say if someone asks you these questions during chat discussion. Can an NDA stop me from working for a competitor? If someone asks you this, you can explain that no, an NDA by itself cannot stop you from working for a competitor. NDAs are mainly about protecting confidential information. However, if the NDA includes a non-compete clause, then restriction may apply depending on the state law. So always remember to clarify the difference between NDA and non-compete agreements and other NSA, NCC agreements. Is it normal to sign an NDA before investment talk or startup pitch? If you are asked this, you can say yes, it is normal. NDAs are often used to protect sensitive information during investment talks or business negotiation, but it is important to check that the NDA does not secretly include non-compete clauses, that it clearly defines the confidential information and that it specifies the duration of protection. Can I use a similar idea in another project after signing an NDA? If this comes up, you can explain. You can use general knowledge, skills, and experience in other projects, but you cannot copy specific confidential information like code databases, formulas, or proprietary models that are protected by NDA. This distinction between general skills and specific confidential information is very important. What if my employee breaches an NDA? If someone asks you about what to do if employee breaches or if the other party breaches an NDA, you can explain that in that case, the company can take several steps. First, send a cease and desist letter. Second, collect evidence of the breach. Third, seek an injunctions to stop user disclosure. Finally, the company may claim damages or use arbitration if it was agreed in the NDA. So there are multiple options depending on situation. NDAs in the US are not just formalities, they are practical tools to protect business information. Their effectiveness depends on clear drafting, correct and detailed definition of confidential information, choosing the right jurisdictions, using additional clauses like NCA, NSA, NCC carefully where allowed, with specific scope, specific territory, and specific duration, and with following the law. A good lawyer should not only know the legal definition, but also understand how NDAs work in a real business situation, considering court cases, technology, and market practices. I hope you found this lecture interesting. Thank you for your attention. Bye.